So, first off, SS versus MC. Rule 43, maintenance for spouse and children and a contribution to costs. This was under the hand of Swanepoel J on the 26th of March 2024. Judgment found circulation within April. Safley citation ZA GPPHC 291, and that is a 2024 judgment. Bundle pages 72 to 80, summary page 8. Now, what happened in terms of SS versus MC? The applicant sought interim maintenance for herself and 3 children as follows. She wanted 9,000 Rand per month per child, 10,000 Rand per month for herself, 200,000 Rand for arrear maintenance, and then ancillary expenses for school, medical, etc. The applicant also sought relocation costs of 60,000 Rand, which she abandoned at the hearing, and a contribution to costs in an amount of 200,000 Rand. Now, what does this judgment look at? It looks at the principles related to Rule 43. What is interesting in this judgment is it looks at retrospective maintenance claims. It looks at lump sum payments under Rule 43. It looks at the inordinate delays in bringing Rule 43 proceedings, and then also unsubstantiated claims for contributions to costs. Now, what happened in this matter? There was an interim maintenance order made of 20,000 Rand per month for the applicant and the minor children. The court did not make a distinction of what portion of the maintenance is for the applicant and which part is for the children, which we know in practice can be problematic. But essentially, 3 minor children, the applicant wanted 39,000 Rand in total, being 10,000 Rand per child and then 9,000 Rand for herself. It looks like the court followed the Solomon approach and gave her 50% of what she asked for. The ancillaries order to a large extent was granted in respect of medical aid and school fees, etc., as well as the respondent to pay the shortfalls. No contribution to costs was given, and no arrears maintenance was given. Now, or no, shall we say, retrospective maintenance was given. Now, what is interesting in this matter, and it's the same thing that vexed me about our Mafeking matter of, I think it was the KBP versus TLP, is the ratio of the court when talking about retrospective maintenance. Paragraph 7 of this judgment, incorrectly numbered 35, I think that was potentially just an error in uploading the judgment to Safley. But paragraph 7, incorrectly numbered 35, the court says the applicant has not provided any explanation for the delay. While the respondent would be compelled to pay all the arrears of maintenance that have accumulated up to May 2022, and consequently be saddled with a substantial liability which he cannot meet. In any event, I am not empowered under Rule 43(1)(a) to order a lump sum payment towards retrospective maintenance. Now, there are 2 things that I'm struggling with under this judgment, and I'd love to hear either on the WhatsApp groups or in the comments whether people agree with me or not. I'm not aware of any reason why a lump sum payment cannot be ordered by a court in terms of Rule 43(1)(a), which deals with interim maintenance. And secondly, I don't think that a court can order arrears maintenance. In this instance, there was no indication by the court that there was either an order by which gave rise to the arrears, or that there was an agreement, either tacit or verbal, in terms of the Maintenance Act, which could give rise to arrears. In this instance, the court doesn't mention anything, but essentially says the respondent would be compelled to pay all the arrears that would have accumulated. It seems to imply that there is something to this claim of retrospective maintenance. I'm not so sure about that. And I say that very, very respectfully to the judge making the order and the court. But I'm certainly not sure whether one can claim maintenance retrospectively. However, as always, I'd love to debate. I would love to learn. If anyone has any inputs, please tell me. Thanks, Corin. I see that you very bravely agree with me there. So let's move on to paragraph 9. Now, very interestingly, the court seems to, in this instance, and I didn't put it on the slide, but there is mention made of the court having to take cognizance of a document not annexed to the papers. Now, I'm going to use this in our next Western Cape decision just to talk about an issue which is quite, I would say, controversial at the moment in the difference between practices between Gauteng divisions and the Western Cape divisions in dealing with Rule 43s. But what the court here says is in the application, the applicant has not said what the issues are likely to be between the parties. She's acknowledged the issue of PRR, of contact and care are not in dispute. She's not attached the pleadings, and the court seems to criticize her for this, but has simply said that the summons is to be found on case lines. There's no plea, and the court cannot ascertain what is and what is not in dispute. Now, obviously, folks, we know for a contribution to costs, roughly stated, you need to set out to the court what the issues are that the litigation is going to center around, what is in dispute, what is not in dispute, what have you paid to your attorney so far, what have they billed, what is outstanding, and what is your draft bill of costs going forward. None of this seems to have been done by the applicant, so quite rightly, she failed in her application for a contribution to costs. Please just put a pin in remembering that the court seems to have, in paragraph 9, where the court says the applicant has not attached the pleadings when taking a point almost against the applicant. It seems that the court puts, I wouldn't say a dim view, but the court would have liked to have the pleadings attached, seems to be the implication. I suppose mediators tell me what is said, what is not said, and what is implied in this particular paragraph.